I'm not threatening you. Say one more word and that's 30 days. 30 days. Court does call the case People versus Radiance Evans.
Good morning. This case is proving to be challenging already. And Ms. Evans will not meet with me. Although in the conversations that I have been able to have with her, she has affirmed her innocence in all charges against her. And she's appeared twice for her PPO violation before Judge Slay. It is my understanding from when I have been able to speak with her that she would like to schedule this for a preliminary examination and proceed in all things available to her. I don't know that if I refer to her competency that she's going to be found not competent based on what I can ascertain of her understanding of all the proceedings, who I am, what she wants to do in terms of her defense. So I would ask that the court set this for a preliminary examination. And then I'm curious to see how the court will respond to my request.
My understanding is she does not wish to come to this hearing. So I'm not going to set it for a further proceeding until she decides she wishes to participate.
Okay.
So I will adjourn this out. Would you like 1 or 2 weeks?
Let's just do 2 weeks.
2 weeks. So I'll adjourn this out June 6th, 2024, 9 a.m.
Thank you, Judge.
Thank you. Bond continued.
Thank you.
Court does call the case People versus Casey Adkin.
That's on.
So she has another PCC before me.
That's my understanding, according.
I'll adjourn this then out 1 week, May 30th, 2024. 9 a.m. Bye.
Thank you, Mr. Canal.
Really? She just leaves before I'm done?
I think she got the date. I thought she thought it was done.
And no, go. Just go. Bound continue. Just start walking. Really?
All right, Judge. Thank you.
No, it's okay. Next one of your clients that does that, I'm snatching you up and sending you back. Court calls the case People versus Daniel Gates.
I ask the court to please set this for exam. Your Honor, discovery is late at this time.
Ms. Hughes, that's true.
Thank you, Your Honor. I downloaded a spreadsheet of defendant's jail calls and sent them to defense counsel, and then I downloaded the relevant jails and sent them to him so we get an opportunity to listen to them. I am requesting that the defendant's jail privileges be revoked. Since his arraignment, the defendant has contacted the victim 13. He actually had another defendant who's present today, we'll hear about him shortly, call the victim of this case and ask her for a different phone number. She provided that different phone number to other defendants that she otherwise doesn't know. And when I searched that different phone number in the jail call system, the only person to have ever called that number is Mr. Gates after that. So I'm requesting that his phone privileges be revoked. And I provided the jail calls to the defense.
I have nothing to add.
Defendant's bond will continue, however, defendant's phone privileges are hereby ordered revoked.
Great Memorial Day weekend, your staff, Your Honor.
Take care. Court calls the case People versus Rajad. Is it Adjef Frashik?
Got it, Judge.
Got it. Did I?
Think you got it?
I knew it. I knew I had it. I knew okay.
Good morning, Your Honor.
Ready, Judge. Torshio Feaster, Assistant Public Defender on behalf of Mr.
Court does call the case People versus Cody Jolly. Your name, sir?
Cody Lee Jolly.
All right. And we have your competency report back. Have you had an opportunity to review that, sir?
I have.
Pardon?
I have.
All right. Is there any other additional evidence you want to give the court?
Not at this time.
None from the people, Your Honor. We would stipulate to the report authored by Graham Parker dated May 7th, 2024, and ask that the court make its finding based on the.
Based upon a review of that report and the only evidence before the court would find that the defendant is competent to stand trial. And that defendant understands the nature and the objects of the proceedings against him and can rationally assist in his defense. And so the defendant is deemed competent. I'd ask the people to prepare an order if you could.
Yes, sir.
In this instance. Mr. Jolly, do you still wish to continue to represent yourself, sir, or do you wish to have the assistance of an attorney?
Continue to represent.
And sir, I do also have to advise you that you are before the court on 2 charges. It's 2 charges. Yes. 2 charges of criminal sexual conduct in the 4th degree. You understand that, sir?
I do understand.
And that these are alleged to have occurred on January 27, 2024. You understand that?
I do understand.
And the court also does have to advise you that these are high court misdemeanors. They are punishable by up to 2 years incarceration and or $500 fine plus court costs, mandatory HIV and STD testing, and DNA would be taken upon your arrest and should have been taken. You understand that, sir?
I do understand.
All right. So, sir, I will formally ask you, do you still wish to proceed without counsel?
Yes, I do.
All right. What do you wish the court to now set this for, sir?
The last that I was aware of was the preliminary exam that we were doing. I'm trying to move forward as quick as possible, so I'd ask you if that's where we start, that's okay. If we move
You
forward,
wish to set for a preliminary examination?
if that's the furthest along I can get, then yes.
Well, that's the next step.
Okay, then yes. That's
All right. So you want to have a preliminary examination in this matter, or you want to proceed to circuit court? There are a number of options that you would have.
okay. Yeah, if we can proceed right to the circuit court, that would be okay.
Okay. All right. But you understand that there would not be a hearing, the preliminary examination, which the court would attempt to make a finding or would make a finding as to whether or not crimes were committed and you committed them. That if you were to proceed directly to circuit court, that hearing would not take place. You understand that?
Trial. Yes, I understand.
Mr. Jolly.
Yes, I do
Mr.
understand.
Jolly. Mr. Jolly.
Yes, sir.
You've been before me, I don't know how many times, right? Are you sure you don't want somebody to just help you make these decisions and to assist you as an attorney in this case?
Again, I choose to represent myself. I was aware of the help and was thankful for the help the other day. If you recommend that I talk with somebody as I leave here.
Well, I'm not going to recommend you do anything. I'm a little bit concerned because when I ask you questions, I don't think you know what you're doing. I don't think you know what you're doing procedurally. And that causes me a bit of a concern. You want to get to, as I told you the last time you were here, you want to get to a certain point. You're not sure how
Let's
to
go back to the
there.
preliminary exam. We can
You
schedule.
want a preliminary examination?
That'll work. Yes, I will.
All right. If you want a preliminary examination, you intend to represent yourself.
Yes.
Is that correct, sir?
Correct.
Do you have all of the discoveries, sir?
I filed for it. I'm gonna have to refile now that I'm competent, but I don't, not when I'm in my possession because I was incarcerated.
All the discovery has not been provided. You don't have it.
It was emailed to me, but I'm incarcerated now, so I don't have it now.
So it was emailed to you when you were out?
Correct.
If the people could try to make sure that whatever discovery is, it be provided to the jail so that they can get it to this defendant.
I can print another copy of the report.
Okay.
Not today. The printer in our office is broken, but there was a media notice that was body, body cam that was given to him in court at one of the last dates.
Okay.
That was on a DVD.
You remember that, sir?
I do remember the disc. Yeah, I didn't. Yeah.
Okay.
So he has the disc.
He has the disc. He just
Another copy of
did the paper report, and we'll get that to you. Okay. Would the people have their witnesses available the 4th, or you need more time? All right. Preliminary examination in person will be set June 11th, 2024, 9 a.m. That's before me. Bond will continue. Okay. All right. Thank you, Mr. Jolly. Court does call the case of the People versus Bruce Jones. Preliminary examination will be set in person June 4th, 2024, 9 a.m. That is before Judge Perry. Bond will continue.
Need to address his other tampering from the last date. I'll go with the phone privileges first. At the last hearing, I believe it was Ms. Barroso requested that his phone privileges be revoked. The defendant requested a hearing on that. After Your Honor then revoked his phone privileges, when the defendant went back to the jail that very same day after leaving your courtroom at 10:50 a.m., he got on the phone and called the victim and advised the victim that you had revoked his phone privileges, and then instructed the victim to download an app called Text Now. And he said, if they're going to take my phone privileges, I'm going to still call you, but another way. And that was after Your Honor revoked his phone privileges. Since then, as far as I can see, his phone privileges have been revoked. But he did manage to get to the phone and make that call after the last hearing of the court today. And then we still have the tether tampering, which is where Community Corrections received the notice that he was cutting his tether. They reached out to him. They asked him to take a picture of his tether to show them that he wasn't cutting it. He refused to do that. And then they see based on his location services that he was then leaving the area that he was in. He was arrested. The tether has a clear cut mark on it, and he told Community Corrections that his dog was chewing on it. So at this point, I'm requesting that Your Honor continue to deny his bond, which was denied after the tether tampering situation, and I'm asking that Your Honor continue the revocation of home privileges.
Any response?
What was that court date for Judge Perry, real quick? I need to know.
Before.
Thank you, Your Honor. Your Honor, I'm going to leave that to the court. My client wants to focus more on the preliminary exam and deal with the case at hand, Judge.
He's waiving the hearing on the phone issue?
Yes, Your Honor.
All right. And the court will order that his phone privileges are revoked as they previously had. And so this bond will continue in all other aspects as revoked.
Thank you, Your Honor.
People versus Christopher Farner. What are we doing?
Your Honor, at this time, we wish to set the for exam.
Preliminary examination in person will be set June 4th, 2024, 9 a.m. before Judge Washington.
I have kind of two options to my request, please. One is I'm requesting that his original bond be ordered at $200,000 cash, and I'm making the request based on that is the request that we made at the time we charged it, and my position is that his bond should have been set at based on the facts of this case. In the alternative, I'm asking that Your Honor revoke the defendant's bond and remand him today for his bond violations. So I'll start with the bond violations, perhaps. After the defendant was arrested and in custody, and after he was arrested, he made 86 attempted calls to the victim, and 23 of those calls were completed. I had the opportunity to download a PDF and send that to defense counsel, as well as download the 23 completed calls. I did also accidentally download some of the incompleted calls and sent those her way as well. But she's had access to them since yesterday, which is when I discovered them. I have not had the opportunity to listen to the content of all of the 23 completed calls. Of the calls that I was able to listen to, I was able to listen to the defendant talking to the victim about arranging his on posted, arranging his pickup at a gas station near the jail, the two of them talking about how to get the no contact order dropped, about how they can have contact with each other once. So I'm requesting that his bond be revoked and that he not be permitted phone privileges in the jail for those violations. In regard to, and I should also note in terms of the jail phone calls, this is the defendant from Mr. Gates' case earlier when I mentioned that he had another defendant from the jail call and asked his victim for another phone call.
The other number?
Yes, this is Mr. Fickner is the person that participated in that, and he's the one that called her victim. Excuse me, Mr. Gates' victim. So in regard,
So he called the victim in the other case to get a new phone number so that that defendant could contact that victim.
correct. Thank you, Your Honor. In regard to the facts of this case, the defendant, and I'll kind of jump to the end and then go back through it. The defendant at the end of this admits to the police that he was intoxicated while driving the vehicle. While he was driving the vehicle, there was minor children in the car, one of which was an 8-year-old child who told the police that while she was in the car, she heard the defendant saying that he was going to crash the car. She experienced that he was driving really fast, and then when they got home, she watched as he was choking her mom. The victim is that child's mom, who reported to the police that in the car, the defendant decided to begin an argument with her, calling her a psychopath, saying to him that she could not take his guns away from him, that he hit her in the head while he was driving, and actually while he was still driving the vehicle, began to strangle her. The victim reported separately from the interview with the child, with the police, reported that the defendant told her while he was driving the car that he was going to crash the car, kill them all, and that it would be her fault. He said that with children in the car, and that the 8-year-old subsequently cooperated that. As I mentioned earlier, he had consumed alcohol and he later admitted to the police that he was intoxicated at the time of driving that vehicle. In the vehicle, put both of his hands around the victim's neck and strangled her. She couldn't breathe. At a stop sign, the victim tried to get out of the car to flee, but the defendant sped off. Once they were home, inside the home, both of her parents were present and her parents were interviewed separately. The victim told the police that the defendant choked her and threw her to the ground. The victim's father, who was present, said that he walked in and he saw the defendant with the victim in a chokehold, that he said, "What the F," except he actually swore, "Are you doing?" And the defendant immediately released her, throwing her to the ground. The mom also was interviewed separately. She said that she saw the victim push the defendant and that the defendant then put his hand on the victim's throat and began pushing her by her neck, and that the mom then left the room and did not see what else happened. The police observed redness on the victim's neck, a V-shape, they put in the report as a blood blister near her trachea. And those are the injuries they observed of her. So just based on the facts alone of this case, I am reviewing my office's response to that would have been the appropriate bond to set at the time. However, if your honor is inclined to, frankly, I'm asking that you just revoke bond completely, set him a bond, remand him for these jail calls and contact he's had with the victim after the agreement, and order that he not be permitted to use the phones in the jail. Thank you, Your Honor.
Response.
Thank you, Your Honor. Our ultimate request is to keep bond set as where it is. As to the allegations of this case, I will just point out they still are allegations. And upon review of discovery, my client does maintain that a lot of what is in the report is incorrect. As to the jail calls, that is correct. Ms. Hughes did.
A lot or all?
Well, some of the identifying information would be correct in the report, but the allegations that would be criminal, my client denies. As to the jail phone calls, that is correct. Ms. Hughes did provide me with both the log and a folder with the calls in them yesterday afternoon. I have had the opportunity to review the log. However, I have not reviewed the substance of the calls in their entirety. I would acknowledge that some of the calls were made to the complaint witness's number and arraignment. However, to my understanding, there are no allegations of any other bond violations, either contact or otherwise, since my client's release from the Washtenaw County Jail.
What about his participation to facilitate another individual violating their bond condition?
The first I'm hearing of that is today, Your Honor. So I can't speak as to that whatsoever. I am asking the court to keep the bond set as where it is. Mr. Fainer has been out for, I believe, how long have you been out since posting your bond?
Last week, Thursday.
Last week, Thursday, so exactly 1 week, Your Honor. To my understanding, in that week, he has not had contact with the complaining witness nor violated his bond in any other way. We are asking for it to stay as is so he continues showing up to court, and he has been very active in the defense for this case. He is a foreman for a construction company and does have full-time work providing for his 5 young children. We are asking the court to keep bond where it is at this time.
Well, I don't know why the bond was set on those facts. Is he on a tether?
Yes, Your Honor.
Given the facts of this case, or at least as they're related to the court, I believe that the bond as set is an abuse of discretion. Everything that's mentioned is high lethality. The alleged victim in this case ended up at least going to the hospital to tend to wounds that she is alleging were caused by the defendant. Moreover, then that after all of this occurs, and what causes the court a great concern is to the defendant's conduct is that there are these contacts that aren't supposed to be contacts while he's in the jail, that then also then while he's in the jail, and I don't have any reason to dispute it because I had to revoke that other individual's own privileges. He facilitates, not only does he violate a condition of his bond, he then facilitates another inmate violate the bond in the case, or in the other case. Not going to happen. It's just simple. I think the bond initially was set wrong. His behavior since then would lead this court to believe that the defendant cannot conduct himself reasonably, would also then pose a danger not only to the community, but to this particular victim and to the community as a whole. Defendant's bond, and he hasn't complied with the bond as we've said it. Mr. Allen, defendant's bond is hereby ordered revoked. His phone privileges are also ordered revoked. Defendant is remanded. Court calls case People versus Victor Hayes.
Thanks, Your Honor. This is going to be a waiver and a bond violation.
Yeah, it may not be a waiver. He's blowing numbers. Why?
Oh, Your Honor, this was
Mr. Allen.
This was an honest mistake on behalf of Mr. Hayes. He had company over on May 8th. He blew a .033 on his SoberLink. He's been on a SoberLink since November, and when he was having dinner, the company that he had with him, his friends and family, they had non-alcoholic wine, and Mr. Hayes was unaware that non-alcoholic wine actually can contain some to little bits of alcohol. So Mr. Hayes just wants this court.
You're going to tell me you got to a .03 on non-alcoholic wine? Is that? No, I mean, if that's what you're telling me, go ahead. I just want to make sure I'm hearing what you're telling me.
Your Honor, I spoke with Mr. Hayes about this, and the only explanation to this violation was what I just stated for the non-alcoholic wine at dinner. And he wants this court to know that this was an honest mistake. He understands that he needs to do his due diligence and make sure that he's not around any alcohol whatsoever. And he would just like you to know that, he's sincerely apologetic, and he's asking this court if it would allow him just to give him a chance to remain out of custody, continue to test while he's doing
Then tell me the truth.
Judge Simpson, can I address the court, please?
If you want.
I've been testing for a while. and this all started in 2022 when I took it upon myself to Sacred Heart. And I'm trying to get some closure to this. And I had company over, and we had what I assumed was a non-alcoholic wine.
Hold on. You assumed it to be, or it was?
I assumed it to be. So I take.
Well, hold it. There's a big difference. Huge difference.
Well, only what I can say is that she said, "Oh, this is non-alcoholic. So I'm not supposed to drink." She said, "Well, this is not non-alcohol." So when I got the call from Mr. Wells and he said that I have blue numbers, I was shocked. It really didn't taste like alcohol, but I take full responsibility. I apologize to the courts. I'm trying to do my best to comply with what the courts want me to do. I've been 000 quite some time.
When you test.
Yes, I see Mr. Allen is behind me, so I know what that means. So I mean, I got a lot of responsibility, and I apologize to the courts. I really do, and this will never happen again.
Well, somebody needs to tell me the truth about what it was, because if one counsel got up here and said you were having non-alcoholic wine, but it has some alcohol in it, that's different than it was non-alcoholic wine, or I thought it was, or I assumed it was.
I understand. Well, when I spoke with Mr. Simpson, Mr. Wells, Judge Simpson, he said, "Don't you know non-alcoholic wine contains some alcohol?" And I never knew that. So it's
not to get you. How much of this wine did you have?
I had a couple glasses, and I mean, it didn't taste like alcohol, but I mean, I had a little buzz, but I didn't realize it was going to cause me to Mr. Allen to be standing behind me. And
you got. Don't you worry about what Mr. Allen's doing. You got.
I'm sorry, Judge.
Story doesn't add up.
I understand.
Because it's not off of. Why is he getting buzzed off of non-alcoholic wine? I mean, you know what you're doing at some point.
Yes.
So if he wants to waive, he'll do it next week.
Understood, Your Honor.
But at this point, defendant's bond is revoked, defendant's remanded.
It's Your Honor.
I get nervous when you're behind me too. Case People versus Thomas Styron.
Public Defender Otatella on behalf of Mr. Styron. Well, let's talk to the judge about that, right?
We've been through this.
What's the confusion?
I've stated multiple times on the record that I wish to represent myself.
Well, I thought we got rid of that issue the last.
Yeah, I thought so too. I spoke to this gentleman right here and expressed my wish to represent myself as well.
All right. Well, if he doesn't want you, I mean, we'll figure that out in a moment. So, Mr. Styron, we're going to go through this again. What do we want to do in this case? You understand what you're charged with, sir?
I understand what the charges are against me, yeah.
Okay, look, you're going to have to give me straightforward answers to my questions because I've got to make sure that you understand certain things. I got to do certain things here.
From my understanding.
You understand, first of all, that if you do indeed direct, you want to smile about it and laugh about it, take him back. We'll call him out later. Take him back. You keep laughing. You laugh one more time, that's 30 days. Go contempt. Look it up. You may need an attorney. Your fault.
That's the forensic center. They also did not sign in, nor have they responded to email.
And Lauren Brown, Deputy Chief Public Defender, appearing on behalf of Mr. Austin.
The forensic center did not sign in for whatever reason.
Your Honor, could we have Deputy Allen stand behind the people at the forensic center?
Get. I know. All right. I'll adjourn these out until the 13th.
All right, thank you. Ms. Allen, be ready.
Yeah, now you want to be friends. Huh? Court does call the case People versus Shaqualin Turner.
Assistant Public Defender Jake Allen on behalf of Mr. Turner, who approaches. We would just be asking for 2 weeks in this matter. It looks like you matter schedule on the 5th. See if we can come to global resolution.
This case that you have today forms the case of bond violation for the domestic violence case. Judge Barr, at my request, revoked bonds until June 5th, the final settlement conference date of the pending domestic violence case.
Got it.
Court to address bond with one aspect.
Yes, sir.
This case we have with the defendant today is a result of the bond violation. He had contact with the victim. There was a disagreement. She called the police. Sheriff's Department encounters the defendant in a different area, and he has a loaded gun in his possession. It's concealed on his person. He doesn't have a CPL. And there is no connection with our ability to proceed on this case and a domestic violence victim's participation. This case is independent. I can prove this case with the deputies. But the fact remains, he committed this offense while he was out on bond on a domestic violence case. And with the date of June 5th being the final settlement conference, I want to make sure that the defendant is still in custody for your date on the 6th. Because if you could take a look at the bond for this case and make sure that it's appropriate given the seriousness of this offense and the nature of him being brought to court in the first place.
Do you have anything to say to that?
I don't, Your Honor.
Well, here's, I guess, what my concern would be. If this carrying a concealed weapon and he's got a loaded firearm, no ability to carry it or no legal ability to carry it. And if I'm hearing it correctly, that although in a different area, he had at some point allegedly had contact with the victim of the domestic violence.
Correct. And it displayed the gun to her. There's no FA charge on this case, right?
I understand that, but that is a big problem. So what I'm going to do, pending any other resolution, while it certainly would not be, can't be a violation. What would concern me, though, is that this violation could have turned into something very, very serious on that domestic violence. So I am going to modify the defendant's bond. And I'm just going to let you know, young man, since at least my initial reaction to it involves the use of a firearm in a domestic situation, maybe. Defendant's bond will be set at $1.5 million cash surety. Mr. Styron, that's all I have left. Tell the jail they're going to have to wait. I'll come back. You just hold him up there. Maybe he'll calm down in the interim. Send to tell him back to talk to him. He calms everybody. Court's going to stand in recess. Ooh, we're going to start with him? All right, let's do that. Court calls the case of the people versus Styron. State your name.
My name is Thomas Styron. Living man.
Mr. Styron, you are before the court. You have elected to represent yourself. I do have to advise you that you have 3 counts against you. The first count is that of fleeing and eluding 3rd degree under the motor vehicle code. Do you understand the nature of that charge, sir?
This is under the assumption that you're compelling me to identify as Thomas York Styron, the legal entity on this case.
I believe that you are. Do you understand the nature of the charge, sir?
I don't understand how the name you have on the case and who I am, it's 2 different people.
I have a complaint, Thomas Styron II. Do you understand that that individual is charged with fleeing and eluding 3rd degree?
So,
do you understand the nature of that charge? You just need to answer my question.
For the record,
take him back, and when he decides he wants to cooperate, we'll bring him back. Maybe. I'm not threatening you. Say one more word and that's 30 days. 30 days. This one. Recalls case, people of the state of Michigan versus Thomas Styron II. Styron, you are before the court on a felony complaint that does allege count 1. And I'm going to presume, since you do not want to answer the court's questions, that you understand English and understand what I'm saying. You are before the court on 3 charges. Count 1 is the charge of fleeing and eluding 3rd degree. Under the Michigan Motor Vehicle Code, that is a felony punishable by up to 5 years incarceration, a $1,000 fine plus court cost, and would require the Secretary of State to suspend your license for up to 1 year upon conviction. Count 2 is assaulting, resisting, and obstructing a police officer. That is a felony or high court misdemeanor punishable by up to 2 years incarceration and or a $2,000 fine plus court cost. Count 3 is a misdemeanor offense of operating with a license suspended, denied, and or revoked. That is a misdemeanor as indicated, punishable by up to 93 days, $500 fine plus court cost. Your vehicle could be subject to immobilization. Since you refused previously to answer my acknowledgement as to whether you understand that, I will assume that you understand what you're charged with. You are also entitled to be represented by counsel at this and all subsequent proceedings. If you cannot afford to hire an attorney would be provided at public expense to represent you in this matter. You are entitled, as indicated, to be represented at this proceeding, all subsequent proceedings, including your preliminary examination, and if the matter were to proceed by trial, you would be entitled to counsel. It is, as we have gone through the previous proceedings, the court's understanding that you do not wish to be represented by counsel, and that this matter will then proceed forth with you representing yourself. I have to advise you that in representing yourself, the court will make the presumption that you understand the Michigan court rules, those regarding both procedure and those regarding evidence. The court will not be providing any legal assistance to you during the course of those proceedings and will hold you to the same standards that I would hold an attorney representing or practicing before this court. So, with all of that, and with the court's understanding that you do not want to be represented by counsel, I will set this matter for its next proceeding.
You understand I'm the beneficiary, not the trustee, right?
That will be the preliminary examination. I will set the preliminary examination. Has discovery been provided to the defendant?
Your Honor, he was previously represented by the public defender. I don't know if they turned over the paperwork to him.
Does anybody from the public defender's office know whether or not the defendant has been provided discovery? Mr. Odetella. Thank you, sir.
Thank you. Your Honor, we have the discovery. I have not been able to share that discovery with Mr. Styron. I tried to speak with him and go over it, but I'd be happy to turn that over to him at first available.
All right. If you would either turn that over to the court officer so that they can provide that to Mr. Styron so that he has the discovery. And if you could do that today, I would appreciate it.
Yes, Your Honor.
I'm setting the preliminary examination. Thank you, sir.
Yes.
The people would have their witnesses available June 11th. Set this matter for preliminary examination in person, June 11th, 2024, 9 a.m. That is before me. Defendant, as he was leaving the courtroom the last time, the court did find the defendant in contempt, sentenced him to 30 days. The defendant will serve that sentence. The court will sign the judgment of sentence regarding the contempt.
I don't understand how that's possible. Like I said,
So first of all, watch your language.
You're treating me as if I'm the trustee, or I don't want to partake in any trust fraud or anything like that. Is this a QVA trust matter involved in this? Is my social security number attached to this at all?
Mr. Styron, or whoever you wish to be addressed as, I'd suggest that you watch yourself because there's going to be more time coming. You keep it up.
You're
You will
presuming
learn,
have
you will
jurisdiction
learn
over
how
the
to conduct yourself appropriately in these proceedings in this courtroom and before me. You will not in any manner whatsoever
You're trying to
disrespect
compel me to be somebody I'm not.
or this
You
institution.
have no evidence
It will not
to prove that
happen.
I'm who you say I
You
am.
will not talk to me in that fashion.
In what fashion? I'm not the one being unethical.
Very good. You'll serve the 30 days. We'll see. We'll see him on the 6th. Bond continued. Who wants to go next? Case People versus John St. Germain.